Denzel Washington stunned the Supreme Court by dismantling decades of law in real time, armed with a Howard Law degree, a secret constitutional theory, and zero patience for judicial condescension. Before the shockwaves in the Supreme Court, there was only a whisper in the Howard Law School basement. A tall man in a ball cap, always late but always prepared, slipping into evening classes after filming on the other coast. Denzel Washington, the Hollywood institution, had enrolled quietly and graduated quieter. His name never appeared in alumni newsletters. Faculty knew, of course, but only a handful. No press, no vanity photo shoots, no commencement speech. He insisted. This was not a brand extension. This was something else. For nearly 5 years, Washington lived in dual timelines, red carpets by day, red lines of the Constitution by night. He poured himself into the Eighth Amendment, obsessed with one specific clause. Nor shall private property be taken, without just compensation. That line, weaponized by law enforcement in forfeiture cases across the country, especially in black neighborhoods, became the axis around which his legal life began to turn. Washington didn't just read law review articles. He spent nights in the Library of Congress digging through 18th-century state court rulings, tracing the slow corrosion of constitutional limits. The world only learned of his legal credentials the day his amicus brief in Henderson v. Department of Justice appeared on the court's docket. At first, the reaction was derision. "A movie star's opinion," scoffed a former U.S. attorney on CNN. But scholars who read the 40-page brief took note. The argument was novel, meticulous, and, to some, dangerously persuasive. Washington's thesis, that civil forfeiture had strayed catastrophically from the original understanding of constitutional limits, and that its modern use amounted to legalized theft from innocent Americans. He wasn't alone. Justices Clarence Thomas and Sonia Sotomayor had raised similar concerns in previous dissents. But Washington had constructed something new, a 3-part constitutional test drawn from forgotten case law and founding-era letters. The court granted his motion to present a 10-minute oral argument. An extraordinary gesture, nearly without precedent. It was understood as symbolic, a nod to civic engagement. But Washington had other plans. 3 months later, he stood at the lectern in courtroom 3, flanked by marble, watched by hundreds. The air was brittle with expectation. Chief Justice John Roberts looked at him and saw not a lawyer, but an actor playing one. "I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." The words hung in the air like smoke. Even seasoned justices shifted in their chairs. The transcript would later record a long pause before Washington replied. What he said next would mark the beginning of one of the most consequential oral arguments in the court's modern history. Washington didn't blink. He didn't gesture, didn't smile, didn't bristle. He merely opened his brief again, placed his finger on page 23, and began to speak. "Chief Justice Roberts," he said evenly, "my position aligns with the original understanding of the Fifth Amendment, as articulated in Timms v. Indiana. If it pleases the court, we can begin there." The moment didn't look dramatic. But constitutional scholars watching knew, Washington had just countered a Chief Justice's insult not with indignation, but with footnotes. He proceeded to walk the court through a history that most law professors only touch once, maybe twice in a career. Maritime seizure law from 1802 to 1865. A line of 19 cases, all involving piracy or customs violations, none involving domestic real estate. This wasn't Wikipedia-level advocacy. It was source-level scholarship. He quoted a letter from Madison to Jefferson, written in 1791, noting the double violence of property seizures without judicial process. Roberts sat back. The rhythm changed. Justice Samuel Alito tried another angle. "What about Bennis v. Michigan?" he asked, a case where the court upheld forfeiture of a car jointly owned by an innocent spouse. Washington didn't flinch. "I believe Bennis was wrongly decided," he said. "And I'm not alone." He pointed to dissents from both Thomas and Ginsburg, jurists from opposite poles. But more importantly, he showed how subsequent rulings in Austin and Timms had already undermined its foundation. For the first time in 25 years, the conservative and liberal wings of the court leaned in at the same time. Justice Kavanaugh raised the real-world concern. "Are you asking us to dismantle the entire civil forfeiture system?" Washington shook his head. "Not dismantle, Justice Kavanaugh. Restore. To its constitutional roots." Behind him, the Solicitor General's office, the nation's legal elite, began furiously rewriting their outline. Court observers noted that time limits seemed to melt. Justice Barrett asked about Washington's theory linking the Takings Clause with due process protections. He cited founding-era scholars, then pulled from a previously unpublished letter Madison wrote in the summer before ratification, which he had personally reviewed in the Library of Congress. No aide, no ghostwriter. Just Washington. By now, something rare was happening. Justices who hadn't spoken in months, Clarence Thomas among them, were asking questions. Real questions. Washington, for his part, never raised his voice. He wasn't selling a performance. He was guiding the court back through history, armed with dusty precedents and constitutional architecture the court itself had helped erode. He concluded with a proposal, a three-part test for civil forfeiture constitutionality. Substantial connection to crime. Proof of owner knowledge or consent. Demonstrable public use. It was clear, administrable, and originalist. And then silence. No. Your time has expired. No rush to move on. Chief Justice Roberts simply said, "Thank you, Mr. Washington. Your argument has been exceptionally informative." A polite phrase. But those listening closely knew better. The Chief Justice had just acknowledged that he'd misjudged everything. Outside the court, it took less than 4 hours for the video clips to go viral. Inside, it took less than 4 minutes for the government's counsel to realize she was in trouble. Her carefully prepared argument, emphasizing law enforcement efficiency and long-standing precedent, landed flat. The court no longer wanted to hear about administrative convenience. They wanted to know why millions of dollars in property had been seized without charges, and why no one had forced them to revisit that until now. The Solicitor General's assistant, seated 2 rows back, visibly closed her laptop. Washington returned to his seat, expression unchanged. He didn't look triumphant. He looked like someone who had simply done the work. Over the next 72 hours, law professors scrambled to rewrite syllabi. The oral argument transcript circulated in every law school. Georgetown held an emergency panel. Yale Law uploaded a lecture titled, "The Washington Doctrine." Constitutional blogs broke down his 3-part test in exhaustive detail. The usual right-left polarization was absent. There was no obvious partisan win to claim, just a searing recentering of constitutional limits. That Friday, the New York Times ran a front-page feature. Denzel Washington, J.D., the argument that may reshape civil forfeiture. It revealed, for the first time, that Washington had graduated summa cum laude from Howard University's School of Law 3 years prior. His professors described a student who came to class with handwritten transcriptions of early American court records. Not out of showmanship. Out of reverence. A week later, the Federalist Society posted a rare endorsement of a position advanced by someone they called a credible originalist in the most unlikely package. The Nation, on the other end of the spectrum, praised his insistence on due process and community protections. Legal Twitter imploded, not with outrage, but consensus. Meanwhile, Chief Justice Roberts found himself in an unfamiliar position. His offhand dismissal of Washington's background had circulated widely. Editorials were careful not to use the word, but the implications were racial, elitist, and damaging. Roberts, who had built his legacy on institutional credibility, knew the court couldn't afford the appearance of gatekeeping brilliance. Internally, clerks reported that deliberations shifted swiftly. Washington's brief, once considered peripheral, had become central. Even justices who disagreed with him were now framing their opinions in dialogue with his framework. By mid-April, something unprecedented occurred. Roberts assigned himself the majority opinion, a signal that the court was moving toward adopting significant parts of Washington's position. Legal analysts understood, it was more than doctrinal. It was reputational. The chief was walking back his own misjudgment. Not with an apology, but with authorship. And yet, Washington never issued a statement. No interviews. No red carpet quotes. He simply released a single line through his representative. "The Constitution is not a performance. It's a duty." The Supreme Court released its opinion in Henderson v. Department of Justice 6 weeks after argument, unusually fast for a case with sweeping constitutional implications. The decision came down 7-2. Majority by Roberts. It was, in tone and substance, an unmistakable retreat from decades of doctrine, and a quiet, almost reverent adoption of Washington's framework. The opinion cited his brief by name 4 times. It quoted the very language he used to describe civil forfeiture as a double violence against rights most sacred in ordered society. And most strikingly, It adopted, nearly verbatim, his proposed three-part test for future forfeiture cases. The ruling didn't ban civil forfeiture. It reset it. From that point forward, the government would have to prove that 1. The property was substantially connected to criminal activity, 2. The owner had actual knowledge or consented, and 3. The seizure served a demonstrable public use, not just generalized revenue generation. In the footnotes, the court included a rare commendation. The court acknowledges the exceptional historical research and advocacy submitted by amicus counsel Mr. Denzel Washington. Justice Sotomayor's concurrence focused on racial disparities. She cited data from Washington's appendix showing that 82% of forfeitures without charges occurred in Black or Latino neighborhoods. When the Constitution fails to protect those with the least procedural power, she wrote, it fails categorically. Justice Thomas's separate concurrence went even further. He called for the eventual overruling of Bennis v. Michigan, a decision Washington had described, politely but firmly, as a constitutional aberration. The dissent came from Justices Alito and Gorsuch, who warned of judicial overreach into an area where the legislature should decide. But even they conceded that Henderson raised disturbing facts. The real story was not the vote count. It was the cultural whiplash. Within days, 3 states announced emergency reviews of their forfeiture statutes. Pennsylvania's Attorney General suspended all ongoing forfeiture proceedings involving uncharged property owners. In Providence, a church that had lost its community center building to an investigation it had no connection to filed for its return. It wasn't just legal fallout. It was architectural. Billboards came down. Bank accounts were unfrozen. Children returned to homes seized years earlier under suspicion alone. For thousands, Henderson didn't just win a case. It reversed a life. In the legal world, professors adjusted their lectures. The Washington argument became required reading in constitutional law seminars. Some scholars, in private, admitted the case had made them question how many potentially transformative legal thinkers had been sidelined by prestige bias. At Howard, a commemorative plaque appeared quietly outside the moot court room. In this space studied a man who reminded the highest court that the Constitution still belongs to the people. The plaque didn't use his full name. It didn't have to. Denzel Washington did not celebrate. Not publicly. As Henderson remade forfeiture law across the country, he remained characteristically silent. No appearances, no op-eds, no interviews. When pressed by a reporter at a film junket, he only said, "The Constitution spoke. That's enough." But the system was less quiet. Within weeks, the American Bar Association invited him to deliver the keynote at its annual conference. Harvard, Columbia, and Stanford all extended visiting fellowships. He declined each. At Howard, he appeared unannounced one afternoon to sit in the back of a first-year constitutional law class. He stayed 90 minutes, asked no questions, and left without a word. The legal world was still adjusting. Many practitioners, especially those who had dismissed him as a celebrity interloper, now referred to him obliquely in interviews, often with carefully measured phrases like, unexpectedly rigorous, or impressively sourced. One former Solicitor General described his brief as better than most I've seen from Supreme Court veterans. Still, Washington showed no interest in becoming a legal personality. He had already founded a nonprofit, the Washington Justice Initiative, dedicated to representing property owners in active forfeiture disputes. The funding came from his own earnings. His name was absent from the materials. Social media, of course, erupted. Memes showed him as a courtroom gladiator. Hashtags trended, hashtag Counsel Washington, hashtag Denzel the System. But among law students, something more grounded took hold. His transcript became a model for persuasive originalist argument. Dozens of moot court teams restructured their cases to mimic his structure, historic foundation, precise doctrine, procedural clarity. One student at Yale, when asked about his method, replied simply, "I try to argue like Denzel." Inside the Supreme Court, the effects were visible too. Justices began citing founding-era materials more frequently: letters, early state rulings, property treatises Washington had revived. In conference, according to a clerk's leak summary, Justice Barrett reportedly observed, "We can't unsee what we saw in Henderson. That's a pivot point." Still, not everyone was comfortable. In a panel hosted by the Federal Judicial Center, one senior judge asked pointedly whether Washington's success had opened the door to amateur constitutional litigation. The remark sparked days of commentary, but the deeper discomfort lingered. The idea that someone without clerkships, without big law experience, without lineage, could enter the court and change its path so thoroughly, unsettled the profession's self-image. Inside DOJ, quiet meetings began. Civil forfeiture remained a revenue stream for local and federal agencies. Reform was coming, yes, but questions remained about what oversight would look like, how new standards would be enforced. Internal emails flagged Washington's framework as legally sound but operationally disruptive. There were whispers of drafting a legislative response to preserve certain powers. Nothing emerged publicly. Meanwhile, communities once gutted by asset seizures began to fight back with tools newly forged by Washington's argument. Local courts in Louisiana, Florida, and New Mexico reversed forfeitures. A pro bono legal network, many trained on Henderson, won a landmark case in Detroit using the Washington test. None of these changes carried his name, but they carried his imprint. And then came the letter. It arrived on official Supreme Court stationery, hand-delivered to Washington's production office under seal. The note was brief. Mr. Washington, I write not as Chief Justice, but as a colleague who underestimated you. Thank you for reminding this court, this country, that legal clarity can come from any quarter. John G. Roberts. Washington showed the letter to no one, but his assistant confirmed its existence after his passing years later. He had folded it into a first edition of the Federalist Papers, page marked at Hamilton's essay on judicial restraint. It wasn't displayed. It was filed. Roberts's note wasn't made public, but its sentiment echoed through a more formal venue weeks later at Georgetown Law, where Roberts and Washington appeared on a panel about civic education. It was their first public encounter since the oral argument. The tone was measured. Mutual. The transcript records few highlights, but one line endured. Roberts, asked by a student how the court could better bridge institutional tradition with public trust, said, "By remembering that wisdom doesn't always wear robes." The audience laughed. But Washington didn't. Or tuxedos, he replied. It was the only moment that drew spontaneous applause. In the months following Henderson, Washington's presence receded again. He declined television requests. He refused a book deal. His only public comment came in a commencement address at Howard's Law School, delivered behind closed doors, with no press, and only one recording, which was not released. Students in the room described a quiet, deliberate message. You will be told what is realistic. You will be told what is conventional. But the Constitution wasn't written by convention. It was written by conviction. Meanwhile, the Washington Justice Initiative expanded into 10 states. Its volunteer lawyers, many of them disillusioned corporate associates, began winning back homes, savings accounts, and small businesses. One office in Raleigh displayed a single quote on its wall. Substance, not stature. But pressure was mounting. Several district courts challenged aspects of the new test, claiming it created burdens on law enforcement. A Republican senator introduced the Asset Security Reform Act, framing it as a defense against unfounded interference. In response, the American Bar Association did something it hadn't done in over a decade. It convened a national commission to evaluate civil forfeiture. Among the expert advisors listed, professors, judges, former prosecutors, was the name Denzel Hayes Washington Jr., J.D. It made the front page of the Wall Street Journal. Not because of the name, but because of the shift it signified, that the man once dismissed as a celebrity fluke was now considered a structural authority. But Washington himself issued no statement. Until a leaked audio clip surfaced. It wasn't meant for public release. The recording came from a closed-door workshop at the Washington Justice Initiative, an internal strategy session, not a press event. A junior staffer had been capturing audio for note-taking. Someone uploaded it anonymously. The clip begins mid-thought. Washington's voice is unmistakable. Calmer than in court. Slower. Measured. I didn't go to law school to impress judges. I went because I was tired of seeing working people lose everything over nothing. A car, a storefront, a house, gone, without even a charge. I grew up around that. I know what it looks like when justice has a price tag and silence is part of the invoice. A pause. Paper rustles. He continues. This was never about me. The only reason it worked is because I wasn't trying to be anyone else. I don't talk like an appellate litigator. I talk like a man who read the Constitution on my mother's kitchen table. And if that's not good enough for the court, the problem isn't with the table. The clip ends there. 72 seconds long. It spread in hours. Legal Twitter reposted it under the hashtag #KitchenTableConstitution. Cable news briefly covered it. But the most meaningful reactions came from law students, many of them first generation, who heard in it not inspiration, but permission to sound like themselves. Washington issued no comment about the leak. A month later, he was back on a film set. No podium. No courtroom. Just another project. But Henderson didn't fade. Within a year, 6 additional circuit courts applied the Washington test. The Department of Justice revised its internal forfeiture protocols, limiting seizures in cases without indictments. State legislatures passed reform bills citing Henderson by name. 1. Illinois titled its statute the Community Property Protection Act. The preamble quoted Washington's oral argument verbatim. At Howard Law, applications from underrepresented students jumped 39%. Several cited him directly. The school quietly endowed a scholarship in his name. He declined a ceremony. And yet the consequences of his moment in courtroom 3 kept rippling. A Supreme Court justice cited Henderson in a separate case on eminent domain. Law review symposia focused not on the substance of Washington's argument, but its structure. A Yale professor titled her keynote, "The Brief That Reframed an Institution." But none of this captured what the moment meant. Because when a man with no formal clerkship, no elite firm behind him, and no legal lineage stands in the highest court in the country and changes the law, there's no sequel. There's only the echo. And it still hasn't faded.